Welcome to Impact Makers Radio, featuring industry thought leaders sharing problem-solving insights to help grow your business and live the life you love. And here's your host, Stewart Andrew Alexander.
Hi, and welcome to another Let's Talk Bankruptcy conversation. And on this segment of the show, ladies and gentlemen, I have Bankruptcy Attorney Amber Kourofsky, Esquire, and she is the owner of AK Law PLLC, all the way from Tampa Bay in good old sunny Florida. Now then, Amber, who is considered to be an authority in the area of bankruptcy, is going to be talking about a very interesting topic today. Amber's here to talk about how to protect money awarded in a divorce proceeding from being discharged in bankruptcy. So, if you are one of the increasing amounts of people in the Tampa Bay area who can relate to today's topic, you might just want to down tools. Log out of Facebook, log out of Twitter, stop Instagramming or any other kind of distraction. Even grab yourself a notepad and pen and get ready to take some notes as you listen in to what Amber has to share with us today. So with that said, let's not keep her waiting any longer. Welcome to the show, Amber.
Well, thank you. I'm very glad to be here today.
And we are so glad to have you as well. So Amber, let's just jump feet first in. Briefly, in your own words, describe the kinds of people who you serve and the various types of situations they find themselves in when they reach out to you for your help.
I am a bankruptcy attorney in the Tampa Bay area, and I typically represent creditors' rights in bankruptcy proceedings. That basically means I provide assistance to individuals or companies who are owed money but are not being paid because of the bankruptcy filing.
It goes without saying that anything that you're about to share with us today from this point on then, Amber, is not legal advice or legal assistance. It's purely for the purpose of sharing information. Now, with that said, I am absolutely 100% sure that while you're out there helping your clients, you come across many misconceptions, as in they come to you with many misconceptions that they believe to be true. For example, they've been on the internet and they've found some information and they believe it to be accurate. However, you know that not to be true, and you have to spend some time dispelling those myths, unraveling those untruths before you can actually get to working with them. So my question is then, Amber, of all the misconceptions that you come across, what's the most common misconception that comes across your table on a day-to-day basis?
Well, I believe the most common misperception with regards to bankruptcy is people believe that they can file bankruptcy, get rid of all of their debt, but keep all of their assets, and that's just not the case. But that's not really related to my topic, and I want to say the most common misconception that's related to my topic would be that people think that because they are awarded something in a family law court for monetary payment or delivery of an asset and a divorce decree, that just because they're awarded it and they're supposed to receive it, that they will, just because it's awarded.
Okay, so based on what you just shared with us then, Amber, and obviously keeping your client's confidentiality in mind, please share an example of how you've helped someone who came to you with that misconception, those challenges that you just described, and what kind of transformational results you were able to gain for them.
Well, I'm going to start with just kind of a little background. So typically when you have a divorce, you have marital assets and marital debts. So money earned at the workplace by the non-needy spouse during the length of the marriage is considered to be a marital asset. Same for debts. So when you have a retirement account or a pension or something associated with the marriage, often those assets can't be distributed at the time of the divorce without a hefty penalty. So to avoid the penalty and a loss of the portion of the asset, what will happen is the courts will award the retirement account to the non-needy spouse since it is technically related to their job. And what happens is the assets are divided unequally, and it's an unequal distribution of assets. So when this happens, they compensate the needy spouse with what's called a equalization payment. An equalization payment is meant to do just exactly what the term implies. It equals out or balances the distribution of assets. And it's used basically when the assets far outweigh the debts. And so they usually are awarded half of the amount of the balance in whatever account or asset at the time of the divorce. The issue when it comes to bankruptcy is an equalization payment is an unsecured debt, and it's dischargeable in bankruptcy. So if you were the needy spouse and you didn't get any of the assets in the divorce and you're expecting an equalization payment to compensate you for that, and then post-divorce your ex-spouse files bankruptcy, if you don't have very careful verbiage in your divorce decree, that equalization payment will be discharged in the bankruptcy, which means that you can't thereafter come and try to collect that money. It's discharged. And if you do try to collect it post-discharge, you actually could be risking getting sanctioned by the federal court. So in order to prevent the equalization payment from being discharged, the needy spouse will have to make sure you have the proper verbiage incorporated into your divorce decree. Because if you don't, not only do you risk the money getting discharged, but you also risk the creditors coming after you for the full amount, because now they can't go after your spouse because they received the discharge and you're the only one liable on the debt.
All right, so just as a reminder, Amber, today's topic is how to protect money awarded in a divorce proceeding from being discharged in bankruptcy. Now, with that in mind, and for those people out there who are wanting to know more about this topic, Amber, what's the most common but unknown pitfall that you'd like them to keep in mind no matter what situation they find themselves in?
Well, again, I just have to say you have to make sure you have the proper bankruptcy verbiage in your settlement agreement or your divorce agreement, because simply just putting non-dischargeable or just putting it as an equalization payment doesn't protect that money from being discharged in bankruptcy. If you want to make sure you get the money, make it as part of a domestic support obligation. Make sure you have the correct code sections in your divorce decree, so that way there's no gray area and you don't have to litigate whether or not that money was intended as support. Because if it's intended as domestic support, if you get a domestic support, you actually get a priority claim in the bankruptcy, which means that they have to pay it, regardless if it's a Chapter 7 or a Chapter 13, just like the IRS or student loans. They're priority claims. You would have a priority claim. Or at a minimum, you would have a non-dischargeable claim that they wouldn't be able to discharge, and then you could collect it through normal means after the discharge.
Okay, Amber, so allow me to just put myself in the place of the listener who's just listening in right now. And it may be an individual or a business owner, whatever the case may be, but they're out there looking at their options for hiring an attorney like yourself, a bankruptcy attorney. What are one or two questions that you feel they should ask that professional to help them to determine whether to move forward with them or not?
Well, that is a really good question. Typically, family law attorneys don't practice bankruptcy. They really don't know. It's a whole family law is a state law typically, and bankruptcy is federal law. So you have the interplay between federal and state, and as you know, in certain situations, federal will trump state. Since the family law attorneys don't know bankruptcy and don't know that area of law, you might want to have them consult a bankruptcy attorney if there's going to be some type of unequal distribution of assets where you're expecting a lump sum payment. For instance, I have a client right now that I'm doing an adversary for. She's supposed to get $130,000 as an equalization payment. This was in 2013. She never received any of the money. Now he's filed bankruptcy, and they have nothing in their decree to protect. She has nothing in the divorce decree to protect her from that debt just being discharged as an unsecured debt.
Right then, Amber. So you've shared a lot of great information so far in the short amount of time that we have allotted today. I'd like you at this stage just to briefly tell us a little bit about yourself, and especially in terms of your background and your formal education and your experience as it relates to the topic of bankruptcy.
Sure, thanks. Well, I grew up in upstate New York, in Rochester, New York, and I earned my Bachelor of Science at Florida State University. And then after I graduated from Florida State, I accepted a position as an account executive at HSBC Beneficial back in New York. And I did that for about 3 years, but then I decided that I wanted to be back in Florida and that I didn't want to work in finance anymore. So that's when I came to Florida in 2007, and I went to Stetson University College of Law. And I graduated and passed the bar in 2010. While at Stetson, I took bankruptcy, and I also interned. I did an internship for the Middle District of Florida under the Honorable Carol Delano. And once I was licensed, I accepted a position working at Clark & Washington, representing debtors in bankruptcy. And ever since then, I have been practicing bankruptcy, and I've represented both debtors and creditors, and I've represented them in all three districts, the Northern, Southern, and Middle District of Florida.
Thanks for sharing that with us, Amber. I'd like you just to think for a moment. Imagine it's any morning of the week, Monday, Tuesday, Wednesday, Thursday, Friday. Doesn't matter which morning of the week. And it's 6, 7 a.m. Your alarm clock goes off and you have a full day ahead of you helping your clients, these people who find themselves in the unfortunate position of facing possible bankruptcy. Even after so many cases, after helping so many people, how does Amber feel on a morning like that? Are you still motivated?
Well, bankruptcy is a very interesting area of law. I feel like it's there to help people. And it really does help everybody in the situation. It doesn't just help the debtor, but it helps the creditor, because the federal government stepping in and saying, let's take a look at the situation and let's figure out how to most fairly accommodate all the parties. So in terms of legal aspects, I find bankruptcy to be very helpful and mostly non-litigious for the most part, because there's one pot of money and everybody wants it to go as far as possible.
Picture the kinds of people who come to you for your help, and they're wanting to know more about how to protect money awarded in a divorce proceeding from being discharged in bankruptcy, which is our topic for today. Now, with that picture in mind, Amber, what final thoughts would you like to share with them before we move on to our last question for today?
Well, my final thought would be something I already touched on earlier, is you just really have to make sure you have the proper verbiage in your divorce decree, because that's going to determine what you're awarded. And if your family law attorney doesn't know bankruptcy-specific verbiage and how to protect you, then just have them reach out to a bankruptcy attorney and get some advice as to how to incorporate that into your divorce decree. But domestic support obligations are the best way to have everything awarded as a domestic support obligation, because in that way it'll be a priority claim and it will be non-dischargeable.
Excellent. Thanks for sharing that with us, Amber. So if there is somebody out there who feels they want to know more about protecting money awarded in a divorce proceeding from being discharged in bankruptcy, how would they find you, Amber? Where would they be able to get in touch with you?
Well, I have a website. It's aklaw.attorney, or you can feel free to email me at amber@aklaw.attorney.
Well, thank you so much. The time has just flown by, and I just really get a sense that we're just scratching the surface of how much you can help. However, we are limited by time, Amber. So again, for you, the listener out there, that was Bankruptcy Attorney Amber Kourofsky. Thank you so much for sharing so generously with us today, Amber. You have certainly demonstrated that you are a true educator and advocate for your client success. So thank you.
Well, thank you. And I was very happy to be here today.
You're so welcome. And even more importantly, I'd like to say a big thank you to you, the listener. Thank you for joining us on what I can only describe as a very insightful and informative discussion with one of the top bankruptcy attorneys in the Tampa Bay, Florida area today. Again, as a reminder, her name was Amber Kourofsky. Don't forget her name. Make sure you do check her out. Give her a phone call. You'll certainly be in the best place to address your current situation. So again, that's it, folks. I'm Stewart Andrew Alexander, and we'll be back shortly with some more leading bankruptcy professionals in this, our series of Let's Talk Bankruptcy Conversations. So until then, take care, have a great day, and we'll talk real soon.
Thank you for tuning in to Impact Makers Radio. To listen to all past, present and future industry thought leaders and trendsetters, visit us at impactmakersradio.com.